in Virginia under 19.2, 392.2, Rob?
Sure. So under the current law, which has been in effect since 1977, you can attempt to expunge a non-conviction record. So it's null cost, dropped. That were dismissed or cases that would are not guilty by a jury. So those cases can most situations be expunged, although automatic that the case will be expunged. So, yeah.
Later, but
Right.
that's the 1977 law, the current law that we have.
And then I think there's some other provisions, particularly if your identity was stolen and somebody uses your identity and they commit crimes. There's actually a process that we are going to use the term easier or easy for someone to have that removed, since clearly they're not the one who offended, who was the offender, as well as what we call an accord and satisfaction. We see that normally in cases where there's been some type of assault, someone's been injured, and the matter is resolved through the payment of medical bills, etc. Those matters can also be expunged. So what happens when
And an absolute pardon.
and an absolute pardon, exactly. So George, in your time of doing defense work, what have you seen when you've had clients? We have a term that we call taken under advisement. What can you tell the audience is about those types of cases and what the problems may be if someone wants to have a matter that was taken under advisement and it was dismissed, and whether or not that can also be expunged?
Unfortunately, in Virginia, charges that were taken under advisement and were dismissed are not eligible to be expunged. So I think there's a lot of misconceptions about that. People think, well, it was dismissed, it won't be on my record, but unfortunately it does stay on your record. And employers can see that, the public can see that. It remains on the online docket where you had this charge, and then it will show that it was dismissed, but your name is out there. It's still on the online docket. I don't know if now is when you want to talk about that, but that will change with the new sealing legislation. Right. The new sealing legislation does allow for charges that were taken under advisement to be dismissed to be sealed under certain circumstances. There's some that are misdemeanors and there are some that
conviction, but it's important for people to know that in Virginia, your Virginia state background check is your arrest record, not just your conviction record.
Right.
So there are people who are denied job opportunities, professional licensing, housing. They're denied the ability to chaperone their children on field trips. They're denied things like being able to be an organ donor recipient. There are things that are taken away from people because right now your conviction can be forever. It is forever a public document, and you have individuals who are denied things like being able to be educated at certain institutions because you have to answer the question around your arrest record more loosely with the non-convictions than not, but they still have been a deterrent to people being able to live sufficient lives. We're talking about quality of life for people, not just, a conviction. And even more stringently looked at is if you have a conviction. Like if individuals don't know, I was wrongfully convicted in 2004 in Henrico court, but it has pushed me to learn the law and be more astute about figuring out the ways to work around that and help individuals through our organization. We have to find second chance employers, people who are willing to hire people who have records imperfect records, where we have to find second chance housing providers who are willing to house individuals and rent to individuals who have past convictions. Every single rental application asks about a criminal conviction, and even though there are protections through the federal program of HUD that say you can't do blanket discrimination in housing, you still have many landlords who deny people the opportunity to live in safe and quality housing because of a past conviction. It can go back as far as 2 years, 20 years, 60 years. You lose your right to vote when you have certain convictions. So that in itself doesn't allow a community of people, and if we're talking in terms of numbers, 1 in 3 adults have some sort of criminal record, right? That means that the families in the communities, not just the head of household, not just the parents, you're talking about the children, are impacted by how much they get to take a part of in our society. We are talking about the fact that, like, I used to always have to rent from private renters, which meant that I didn't get the option to stay in apartments where all utilities were included. So being house burdened, paying more than 30% of my income in rent, and also paying for landscaping, paying for utilities, gas, water, all those things. And we don't look at that. We allow our social services systems to assist people when they don't have quality employment and help with things like childcare. But we won't allow people to live a sufficient life and make good income so that they can take care of themselves, and we don't have to depend on society and different systems. So in the very basic need, and I'm not an attorney, we do advisement because I am knee deep in this work, and I really started, it didn't just start in 2021 when the bill was passed. My sister was acquitted of a crime in 1999, and we found out she had to be fingerprinted again, which was a barrier that a lot of people who have non-convictions were not willing to do to get relief. Right. So we advocated really hard, and we got fingerprinting removed from the 2025 bill. People don't have to be embarrassed or go back into a police station or Virginia State Police headquarters to be fingerprinted because they already have their fingerprints on file. Also, she had to pay $98 per charge. Sorry. She had to pay $98 per charge to have things removed that she had been acquitted of, and that could have been a barrier. So my work in expungement and now what we call record sealing started in 1999. I'm only 25, but it's still 1999. So, it really was getting down to the nuts and bolts of what do we do to make people's lives better, even with convictions. And it took a long time to convince the General Assembly to pass something that gave relief for people who have records and have been living with records, because right now it is forever.
Right. And I think that's a really good point that you've made about the notion of not just, can I look into the system, and in general district court, they're only going to have that record for 10 years on the computer. But if I have my actual records run through the Virginia Criminal Information Network, which is the system that the state police manages and they're in charge of, that misdemeanor charge will show up. And I think it's also really important to understand that, even though people have had cases dismissed, they were found not guilty, or the case was null pros, as in the prosecutor decided for whatever reason at that time not to go forward. Even those words can still be an impediment for someone to get housing, or they have more questions being asked of them to be able to move forward. So Rob, I'd like to turn it over to you, and within your capacity, even before you became like the executive director of Justice Forward, tell us what was it like when an individual would come to you, or you had a client that you had just represented and they had their case dismissed for the reasons that are proper under the expungement statute as it stands now. What were the procedures that one would have to go through?
Yeah, so I'll never forget my first LAGC client, because that person said, they were one of the select few. If you never had any convictions under the current expungement law, if you've been charged with crimes and those crimes have been dismissed or null prossed, then you sort of get the fast track you're sort of like presumptively eligible would be the lawyer phrase for it. And the prosecutor has to show why you shouldn't get your charges expunged. So you want to be in that group if you can under the current law. She was in that group and still was not going to go through the process because of the fingerprinting barrier. Had been, was being asked to go back to the same law enforcement agency to do fingerprints where she'd been wrongfully accused of the crimes to begin with. And that was barrier enough for her not to even want to do this unless I went with her and got the stood with her while she got her fingerprints done. So that was an eye opener for me and why we pushed so hard to get the fingerprint requirement out of the new legislation. And by the way, it's going to be out of the old law too, because of legislation that passed this year. So there will no longer be fingerprinting of any kind required for expungement or sealing as of 2025, when this year's law takes effect. Another thing is, people just wanting to do whatever they can to make their record look less bad when they're applying for jobs or for housing. So you might have 3 convictions, but you might also have, 20 charges that were dropped or dismissed. And all of those show up when someone searches your name on the online case information system at vacourts.gov. And, we ask employers and landlords to make these decisions, but they're not lawyers. They're just seeing this screen full of charges. They're not necessarily going in and into each one and figuring out which ones are convictions. So it's understandable, like why you would want to make sure that as many charges as you can take off that list come off that list. And unfortunately, under the 1977 law, the current expungement law, if you go into court and you have any conviction at all on your record, it's really hard to get your non-conviction records removed because you have to show that sorry to do legalese, but you have to show that continued dissemination of your non-conviction record would cause a manifest injustice to you. And you're having to prove that it's the non-conviction record that is the one causing you a problem or could cause you a problem when you also have convictions on your record. And there are some judges in the Commonwealth of Virginia who say, if you have any convictions on your record, you can't show that the non-conviction record is going to be the one to cause you a problem. So I'm just not going to expunge it. And I've lost those hearings where judges have told me that. They say, this statute was designed for innocent people. And they get that from 19.2.392.1, the statement of policy, which is also going to change in 2025, thankfully. But they get that from the 1977 General Assembly, which said we're trying to help innocent people remove their records. That's what the expungement law is about. And we've gotten to the point now where that is outdated. And thankfully the General Assembly has recognized that. It's outdated because of the internet. And 97% of employers checking someone's criminal record before they allow that person to work. And upwards of 90% of landlords checking a person's criminal record before they allow that person to live in their housing. So we're living in a different world than the 1977 law envisioned. And fortunately, the 2021 General Assembly recognized that. And so we'll get the benefits in 2 years.
So George, so I come to you, there is a process there in order for someone to actually get before the court. So what can you tell the folks out there about what the actual process is about that?
For the expungement, the current expungement?
For the current expungement, yeah.
So for the current expungement, you have to, and it varies depending on the jurisdiction. Each jurisdiction has procedures a little bit different, but you have to file a petition to have your charge expunged. There is a form petition that is available through the state Supreme Court. That is made available to people much more easily in some jurisdictions than others. It's at the clerk's office in some jurisdictions, it's online for the clerk's offices in some jurisdictions, and other jurisdictions it's not. So the first thing you have to do is you have to file the petition for expungement. There's also the issue of the fingerprinting, which I suspect still exists now, but in 25 will, you won't have to do that for the expungements. So you file that, and then the Commonwealth attorney has an option, or has the ability to respond. They can either object or not. And what we've talked about doing in Henrico and started working on is that some other jurisdictions do this, is that there can be an affidavit that is filed with the petition that demonstrates that manifest injustice, that fancy word that nobody knows what it means. I don't think it exists anywhere else in the law. But you file this affidavit that says that there is manifest injustice. When the Commonwealth attorney then receives it, if they file a response that says that they don't have an objection, then it's a lot easier. You don't even have to go to court. The judge can just sign an order. There's a form order that can also be prepared. And this is also provided by the state Supreme Court. So in a lot of jurisdictions, it can be very easy. In other jurisdictions, you actually have to go to court. And then a lot of people are intimidated by that, understandably. And it is certainly something that folks can do on their own. I have encouraged people to do it on their own. I've seen people do it on their own, and they have been successful with it. But a lot of times people end up hiring an attorney to help them with that also. So in a lot of jurisdictions, then you end up with a hearing in front of the judge, and in front of the judge, you're trying to prove that there's this manifest injustice. So that's essentially procedurally what happens. One thing I want to jump on with what Rob said is that with the new sealing legislation, I think people might want to consider having charges expunged now, or trying to have them expunged now, if you have a conviction that is eligible to be sealed in 2025. It's not uncommon that folks go to court, the charges is, they have two charges, one charge is dismissed, and one charge they are convicted of. There was a plea agreement. The charge that you were found not guilty of, that is eligible to be expunged. And what Rob was saying, a lot of judges are reluctant to do that now because you have this conviction that is still there. But my argument to folks is consider doing the expungement now on the charge that could be expunged now, and argue to the judge, hey, I'm filing July 1st of 2025 to have this conviction sealed. That's the manifest justice. So let's have this expungement done today. There's going to be a lot of paperwork that's going to be done July 1st of 2025. So my argument to folks is, hey, try to get the expungement done now, have the sealing done on July 1st of 2025. So if you can have it expunged, you might as well have it done, so that when your charge is sealed, the expungement has already been done and nobody can see anything publicly about your charge.
Yeah, and I need to emphasize this, that while I'm proud to say that this is a Henrico sponsored event with my office and the Henrico chapter of the NAACP, this really is something that is determinative jurisdiction by jurisdiction, prosecutor's office by prosecutor's office, judge by judge. So making sure that you are informed about the locality that you're trying to operate in is a critical part of this. So that's why it's good to have entities like Justice Forward, like NoLef Turns, like Clean Slate, so that you have people to reach out to say, this is my situation. What do I do next? I'll talk a little bit about some things that have changed that will be part of the sealing, but would like to hear a little bit, Rob, about the policy behind it. So we've had the legalization of adult recreation marijuana. We've had the idea that it's no longer a criminal offense, it is a civil offense. Can you, in your dealings with proposing legislation, trying to identify what should be sealed, what is fitting under which categories. Can you tell people about, like, when we talk about sealing, what categories of types of crimes we're talking about? Violent versus nonviolent, people crimes versus property crimes, misdemeanors versus felonies. What can you give the people who are paying attention right now about that nuance to the sealing law?
Yeah, so first I want to make a caveat, and I think Sheila will be on board for this because I've heard her say it at another one of these events, which is, this is not quite the law we thought we were going to get, and it's not the law that we necessarily are 100% happy with. This is the law that was the result of a lot of compromise in order to get it passed. So I just want to, and I've actually written a whole blog post about the process. So if you want to go read that, knock yourself out. But I mean, at the very end, just to give you a little snippet of it, the governor actually stepped in, Governor Northam stepped in when the House and the Senate were controlled both by Democrats. The governor, who also was a Democrat, had to step in to hire a mediator to come in and resolve the differences between the House and the Senate, because we tried this in 2020 in the special session, and they were so far apart with this legislation between the two chambers that it was irreconcilable, and we left the 2020 special session with nothing. And so when they came back in 2021, the governor, to his credit, said, we're going to get something. I'm going to sign something. Now you go sit in a room and tell me what it is, and then I'll sign it. So there was much compromise. There was much done, behind the scenes. And it appeared one day and we said, okay, I guess this is the bill. And then we supported the heck out of it because we needed to, and it's going to be good for a whole lot of people. So I just wanted to start with that. In the final legislation, I won't talk about the drafts.
Right.
In the final legislation, there will be a handful of charges, of misdemeanor charges, convictions, that will be automatically sealed if you meet certain criteria. So these are things like possession of marijuana, misdemeanor possession with intent to distribute marijuana, disorderly conduct, shoplifting, trespass, concealment, which is another type of shoplifting or petty larceny. There's like 4 different kinds of trespass. Don't worry about that. But those are, I think, all of the charges that will be automatically sealed if you have no convictions for the 7 years after you got that conviction. So say you're convicted of disorderly conduct in 2018, June 30th, 2018, on July 1st, 2025, you will be eligible for that charge to be automatically sealed. I should say the automatic sealing part isn't going to start until October. So it's going to take a few months because there's a whole lot of sharing of information that has to happen, but you won't have to do anything. You won't have to go through the court process. So for those handful of charges, automatically sealed. Then for every other type of misdemeanor, except for 2, I'll come back to those. For every other type of misdemeanor conviction, the same 7-year rule applies, but you have to go through the petition process. So if you got an assault and battery conviction, you don't have any convictions for 7 years after that, you petition, you go through the circuit court process, and you can get that conviction sealed, that assault and battery conviction sealed. The 2 that are not eligible for sealing of any type are DUI and assault and battery on a family or household member. And that is ostensibly because of some federal funding issues that we don't need to get into, but there's some worry, there's some people in the legislature who had some worry that Virginia would no longer receive certain federal funding if those 2 charges were made eligible for sealing. Then we get to felonies. And again, all the felony stuff is going to be by the petition process only. There's no automatic sealing of any felonies. And it's not the distinction they made, I think to their credit, is not between so-called violent and non-violent offenses. Because there's a lot of problems with that distinction, which, you know, I would be happy to put my justice forward hat on and talk about. But to their credit, they made it based on the level of offense. And they generally stayed to the lower levels. Doesn't mean there aren't violent stuff in there, but so-called violent stuff, but it is the lower levels. So class 6 felonies, which is anything up to 5 years in prison, class 5 felonies, which is up to 1 to 10 years in prison, and then unclassified larceny offenses. So grand larceny can carry up to 20 years. It's unclassified, but will be eligible for sealing under the new law. And with felonies, you can't have any convictions in the 10 years following your conviction in order to be eligible.
So Sheba, so like with your organization, what are you advising people today about the process that exists today and what we will be seeing effective July 1 of 2025?
So we get a lot of people who come to us and just don't understand the law at all. And it was a very, very complicated thing being a lay person. So we have to explain. We have to explain what's eligible, when it will become eligible. We get a lot of requests from people who say, look, I haven't been in trouble in 20 years. This needs to be removed now. And we have to break the news that that's not the case. We have to explain that Virginia never upgraded their computer system, and we're operating on a system that's probably older than MS-DOS, and they got $25 million to complete the process. Because people want to know, why does it take so long from the date that the law was passed to implementation? We have to explain that we don't know what type of notification system will happen, if they will be notified, if they have an automatic removal, if they're notified that they will be eligible, if they're notified of anything, if we're depending on the administration. We work really closely with Code for Virginia in Charlottesville to document, they scrape data from the past 20 years in court convictions, and even looking at all of the nuanced, crazy ways that different localities list their charges to see which charges were charged most. Not surprisingly, driving on suspended license was huge, but again, because of federal funding, that wasn't something that could have been put into practice. And it's really important for people to understand. A lot of people think that we just advocated for this, the settlement in the bill. When the bill first was compromised on the House side, which we supported because we supported free automatic and far-reaching expungement, I would not have qualified. And a lot of the people on the expungement council would not have qualified for relief, but we wanted people to not go through a process where they had to go before a judge for the most part. So we're explaining all of the very nuanced things that are coming along with the bill and why there's a waiting period, what can be removed, what won't be removed, and how they can get involved to advocate for expanding the bill that we currently have. A lot of the things that are passed in General Assembly come from people stepping up and sharing their stories and how these things impact them, because believe it or not, a lot of legislators don't go through the same things that we go through as human beings in these streets when we're stopped or wrongfully charged with crimes. There's immunity in some cases, so they may have never even set foot in a courtroom for the most part. Yes, we see a lot of craziness now with our legislators being arrested or charged with certain things, but for the most part, they don't go through the process. So they don't know how a non-conviction, even a non-conviction, may impact a person. And that comes down to privilege. But if you're an average everyday person who works and lives and breathes in this state, then you know what it takes when you have to answer that question. Even we had conversations with the CEOs of Medicaid for this region to say, they are in charge of whether or not a person can work in a medical setting or get a professional license with a barrier crime based on what comes up on a record for a non-conviction. So just giving people the information in a very basic term, because legalese is not something that a lot of people follow. Understanding what manifest injustice is the basic question that people are like, what does this even mean? Yes, it causes harm. Yes, it keeps people from doing this, but they have to know what the courts are looking at it as. And Shannon, stop saying advisement because I'm not an attorney. I just give it to them from my standpoint. I share my story. You know, and I tell people what we have to look forward to and what we have to do to continue this fight, because we can't just stop at what we have.
Right.
Like, people, I believe, and this is my uncredited opinion, even a guilty person deserves dignity. The reason why we fight so hard for everybody to have access to record sealing or clearing or expungement or whatever you want to call it is because we put so much onus on the judge and the jury, giving person the time that is sufficient for whatever crime they've been convicted of or charged with. And when they complete that time, we still take away their basic human dignity and needs. So we fight for everybody. We didn't win with everybody, but we continue this fight. We meet every 2 weeks as the Virginia Expungement Council and strategize around how we can make things better for people who live in our Commonwealth. Public safety is not having people deal with the 46,000 collateral consequences that come behind a conviction or an arrest. Public safety is making sure that people have the resources they need to be self-sufficient and not depend on the state or the welfare system to help them through. People should be able to do the time that they get for whatever crime they're convicted of and move past that and still have a good quality of life where they're not constantly answering the question about, have you ever been convicted of a crime?
And George, I'll ask you to kind of to follow up on that as an attorney. Obviously, there's Sheba doing the good work through the nonprofit, through her organization. But as an attorney, how are you also trying to get the word out? How when you're getting calls from, you know, clients today, or maybe they're the future clients, how are you engaging in this discussion?
Well, I'm doing my best to, you know, through the internet and all that, Facebook and everything, to let people know about the legislation. There's a lot of confusion out there between expungements and sealing and who qualifies and what. And so I'm just doing my best to try to educate people. What, you know, an expungement is for something that was dismissed. Somehow it was dismissed. This new sealing legislation is going to be much more impactful, and it's going to affect a lot more people because it is actually for some convictions. So I'm doing what I can just to educate people, and I'm a criminal defense attorney. So I'm letting people know when I represent them on charges, whether they're acquitted or found guilty, hey, there's this legislation. You might have just been convicted of this felony, but there is a light at the end of the tunnel. That if you go without another conviction for 10 years, it can be sealed. And, you know, I realize that that's a long time. I know, I understand that. I certainly recognize that. But as the law stands today, you know, that I'm informing people, I'm letting people know about that. And the biggest thing, though, is just clearing up all the misconceptions. People just don't understand, and it's letting them know what the law is and how they can take advantage of the laws.
So I know there are some questions, but there's one thing that is important to me that is looming out there. And for all of the great efforts that we're doing, I think it's important to know two things. First of all, it is currently a criminal charge that if someone has had their record expunged and you talk about that person having been arrested for that charge, or having, you know, been to court on a charge after it has been expunged, that is illegal. You cannot do that. So that's one thing I want to make sure everyone understands, because why, you know, we're trying to honor what this is about, which is removing this quote unquote label and removing it, period. So if it's been removed, you should never talk about it again. But in this day of internet, social media, advertising, et cetera. Rob, I'm going to go back to you because I know this was, as much as you were reading the 87 pages of the bill, I also was reading it from the prosecutor's point of view. And I know something that was really important to Senator Surabel, which will not be lost on anybody here, is what do you do about the websites who keep the records, who talked about the charge of the person getting arrested, but then they were acquitted by the jury. And so now that they've had that, like, how are we going to tackle the big problem of data in the internet universe? And what do you see are potential next steps to address those issues? Yeah.
Yeah. Yeah, you know, first of all, we do have a First Amendment. So when we're talking about, people who've had things expunged and it's illegal to ever talk about it again, that doesn't mean that the Daily Press reporter who reported on, the incident at the time and put that out in the universe and continues to do so because their website is still up and that story is still there, doesn't mean that they're doing anything wrong, because the First Amendment, protects them. But I think the point you were getting to is, what about these companies? And this is really one of the grosser aspects, I think, of this whole issue, is that there are companies who profit by selling other people's criminal records. And I just have to sit with that every time I say it, because your livelihood is selling other people's criminal records, making their lives that much more difficult. Of course, they don't see it that way. They see themselves as protecting landlords and employers. But they're out there and they package and repackage these criminal records. And so Senator Surabel talked to some, I think, really excellent lawyers down in Hampton Roads who work on behalf of people who've had to deal with this issue of getting expunged records, really cleared from these companies who just seem to repackage them and sell them again, even after they've been expunged. And then he met with all the criminal record, the sort of data broker people who are the ones buying and selling these records, and said, we've got to do something about this. And so under the law, there will be an opportunity for people if they find out that their record is being sold. And you would find out when you go to apply for a job and the employer says, sorry, your record check came back, you got this charge. You can ask them, you can say, I want to know who you got that information from, and then they should give it to you. And then when they do, you can look at it. And if you see a record on there that was sealed or expunged, you may have a remedy under the new sealing law, which is that you can sue them for money damages, or the Attorney General can also do that. So that is, I think we're one of like maybe 2 or 3 states in the country that's going to have that provision, and that is thanks to Senator Surabel. That was all him putting that in the bill. Registration. And people who want to engage in that business in the Commonwealth of Virginia have to register with the state police. So one of the issues about finding these companies, because they set up little shell corporations and they sort of disappear. In order for them to do business in the Commonwealth of Virginia and make a profit, they will have to register with the Virginia State Police. So we will have an address on file where they can be served with process if they're going to be sued by the Attorney General or the subject of the records. They will be registered with the state police so that people are able to sue them.
There's also a mechanism for people to be able to verify that it was taken off as records, right?
Chain it.
Yeah.
Got it.
There's also a mechanism that once a conviction is sealed, that you can contact each one of these companies that has registered to verify that your conviction is no longer being reported. So I think that's a great part of the law that, I think in a lot of other states, it's supposed to come off your record. We don't know if it's going to or not, but in Virginia, now there's a cause of action, and there's a list of the companies that can report your convictions, and you can go to them and find out, hey, have you taken it off? It's been sealed. I'm verifying this because I'm applying for a job tomorrow.
Okay, so like we said at the beginning, we have people who are watching online as well, live here in the audience. And we do have a couple of questions that came in online. And I think I'm gonna read this one out loud, and I think I know what they're talking about. So can someone who is on unsupervised supervision, are they able to seal or expunge those non-conviction charges? That sounds like it's a question about, Rob, like you were saying, if they have, 2 convictions on their record, but then they had 3 charges that were null pros, There's some judges that are saying, I'm not gonna allow you to do this because how do we know that the quote unquote manifest injustice is coming from these null pros charges? But the idea of being on probation, does that play a role in any of this?
Not for expungement, it would, yeah, so. I mean, the best answer is it's gonna depend on the jurisdiction, and it sounds like George and I practice in different jurisdictions. Because, you go out to Fluvanna or, Augusta, and I think you're gonna have, a lot different time than you would in maybe Henrico or Charlottesville. Because where you have some friendlier Commonwealth attorneys that can really smooth the process. But it's all, it's just sort of the luck of the draw where your charges were, right? Can't do anything about that after the fact. So, unfortunately, this is, I would say this area of the law, and by the way, I think there's 7 justices on the Virginia Supreme Court who agree with me on this point, which is that the General Assembly has really mucked up the 1977 expungement law to the point where it is really hard even for courts to understand what it was they were trying to do. It really needs a total rewrite, which I would be happy to offer my services. But we're stuck with the law we have, and it is dependent on the jurisdiction, whether the judge would sign off on the manifest injustice piece, because the judges just read that differently.
Yeah, and hold on to that, Mike. Just there's 2 things. The idea about, the idea about why it was delayed to be enacted in 2025 was to give state police and give the Commonwealth of Virginia time to come up with some type of software program that was going to be able to handle, which was going to be anticipated, a very large number of these applications and to be able to process that. That doesn't necessarily mean that the mechanics of the bill itself have been vetted by courts yet, but that was what the purpose was for the delay. So one of the other questions was, what is the name of the expungement bill? And so we've been talking, I started off by giving the citation of 19.2 392.2, which was expungement. But the actual, if anyone wants to read the sealing statute, what would also be this code citation for that?
So you'd start at 19.2 through 92.5, and then keep going to, I think, 19.2 through 92.16.
16 or 17.
Yeah.
16 or 17?
I think it's 17.
So if you're looking at the code website, which is law.las.virginia.gov, and you click on the Code of Virginia, and then you would go to Title 19.2, and then there will be a chapter on expungement, which is 19.2 through 92.1 to 392.4.
Yes, chapter 23.1.
Okay.
Yeah.
And then the next one immediately following that, starting at 19.2 through 92.5. And so on, will be the sealing law.
Okay. Then another online question, does expungement or sealing affect sentencing guidelines? Should someone reoffend after either occurs? That's an excellent question.
Very good question.
Yeah, and George, why don't you answer that question?
I think unfortunately the answer is yes. Well, we've talked about a lot of the benefits of sealing, the sealing legislation. One of the things that we didn't talk about was that once a conviction is sealed, you can deny it when you're applying for a job. You can deny the arrest, you can deny the conviction. But there are, with any law, there are a number of exceptions. And I think to this law, there's 25 exceptions, and they're all listed in the code. And essentially, they are, for the most part, they are all law enforcement related exceptions. And so what's going to happen once you have a conviction that is sealed, you're going to have the NCIC, which is the report that law enforcement, Commonwealth attorneys can see. And it's going to show that there was a conviction, and it's going to show that it was sealed. That is still going to exist for law enforcement purposes. So for law enforcement purposes, it will still exist. And it still can be considered for law enforcement purposes.
And I'll go ahead and add that when we were talking about the negotiations that were going on, one of the things that prosecutors still wanted to have the ability to do was be able to see if they could challenge someone's credibility. So if somebody, you know, the law of evidence allows that if someone takes the stand and they have a conviction, a felony conviction, or what we call the moral turpitude, the lying, cheating, or stealing misdemeanors, prosecutors still wanted to have some ability to test that person's credibility. But even then, that would be subject to litigation about the impact of what a sealing order is all about, and how far that's going to go. So the mechanics of that is another wait and see moment. All right, let's see. Do we have any more online questions?
No.
Okay, so now I will turn it over to the audience to see if there are any questions in the audience about the subject. Yes, sir.
Question. So I guess with the big thing, like you mentioned at the beginning, somebody got pulled over, running the crime. See if like you can credit for checking criminal records involved.
So the question was, if I was driving down the road and I got pulled over and I gave them George Townsend's ID, and I'm doing that because I don't want them to know that Shannon Taylor's got an outstanding warrant. When they go and for some reason I'm not arrested there on the at the moment, but the police officer goes and gets a warrant for George Townsend, and they go arrest him, and he's like, I wasn't even in town. How could I have been driving down the road and you pulled me over because I wasn't even here? So George is still going to come to court, and he's going to say, Judge, look, here's my receipt. I wasn't even in town. That couldn't have been me. And then the officer going to be like, yeah, that's not the same person I pulled over. Because it's not necessarily the same person who pulled you over that you then come in contact with later if there's a warrant that's out there. So George could say, well, look, they stole my identity. That's mistaken. And he should be able to go to the clerk's office, fill out a piece of paper, and not pay one red penny, and the judge should be able to sign off on that without any problems. That's how it's supposed to happen. George, have you had any clients that
Well, I
said,
mean,
is that easy?
it can be expunged. I think to answer your question, yes, that it can be expunged.
Yes.
Is it that easy? No. I mean, it's the petition. You're still paying the fee. Right now, you're still having the fingerprints done. But to answer your question, yes, that does qualify for an expungement. If somebody else got a charge in your name, it can be expunged.
Yeah.
Anything that happened that we might not know about that a long time.
Right.
So let's restate the question. So to restate, this is an excellent question that we didn't really dig into, but how about, something that happened 30 years ago? I mean, some people have good memories, some people have bad memories, and they need to know exactly everything that has happened every time they've had contact, had a warrant. And it's important to know that it's the warrants where you're actually getting fingerprinted, because the difference between a summons, sometimes you might just get a written summons and never get fingerprinted. So that will never come up on that NCIC. But anytime that you got fingerprinted, those are the charges we're really worried about, because that's what's being tracked by this machine that state police runs. So how does one go and say, all right, Mr. State Police, I need to figure out exactly how many times I've been arrested. And can you give me a copy of my record? So Sheba, what do you tell people who are asking that question?
So the most important thing, you can request your Virginia State background check from Virginia State Police anytime. You pay, it's anywhere like from $8 if you don't want the sex offender registry one, $16 if you do it through a nonprofit, it's a little bit cheaper, but you can always request your Virginia State background check. Unfortunately, I had a situation where I applied for a job at a child agency, and I had to do an FBI fingerprint. I had to go to a Virginia police station and get fingerprinted. My conviction came back in 2004. They didn't have a problem with that. A contempt of court charge came back from, I don't even know when it came back. But what I had to do was go to the clerk of courts in Richmond and have them pull the old file. The clerk of court actually wrote a letter on my behalf because there was no way that I was there at that time. And I could prove because I was in college. But they wrote a letter and had it removed from my record. It's not always that simple. Typically, your fingerprints will be the key to show, because like years ago, and this is off my record, fact check, like people used to use other people's ID, like, you know, use my sister's ID to go to the club and things like that. It was very common for people to use other people's IDs, but you cannot change that fingerprint. So if it was an arrest where an individual was fingerprinted and you know that it's not you, that FBI background check, that Virginia State Police background check will show that it did not match. So those are the steps. Like sometimes it is as simple as going to the clerk and proving that this could not have been you. Could have been a clerical error. I remember when my ex was paying his fines and fees and they mixed up his record with somebody else. It was an easy fix, but it's not always an easy fix. Sometimes, most times, you have to get a fingerprint card and have it run against their records to show that this was not you. So that was my situation, you know, try to rectify it as much as possible. It's not always nuanced. And there's something that is completely unrelated that I wanna tell people. Like a lot of times, because of the way that our county lines, city lines are, you may have convictions in different jurisdictions. And a lot of people think as we start doing these clinics that I have convictions in Richmond, Henrico, Chesterfield. We can only do the locality that we're in at the moment. And for people who are doing it themselves pro se, they will have to go to each individual locality to have these things rectified as they go through the process. So I wanted to point that out because I don't think we touched on that. And I know that has nothing to do with your question, but yes, fingerprints a lot of time will alleviate that issue. We can request your background check from Virginia State Police at any time. And if you want to do it, go further, there's an FBI background check that can be gathered through Virginia State Police as well. Input.
Again, that's perfect. Yes, ma'am.
So I know you guys have mentioned expungement and dealing, compensation. Kind of like interchangeably, but those are two very different things, correct? I just want to make sure that everybody.
Yeah, the question was, you know, like I said in the very beginning, we're using the term expungement and using the term sealing. Those are two different processes right now. Right now, the only thing you can do in Virginia is get your record, quote unquote, expunged. The idea of sealing your record will be able to be in effect July 1 of 2025. So yes, we want to make sure we say that often.
And the expungement is for the dismissed charges.
An expungement for dismissed charges that right now, if you do something like called taken under advisement, meaning you do all these things the judge tells you to do. Right now, those cannot be expunged, but those will be expunged in 2025. Any other questions? Because we're gonna wrap up. I'm gonna wrap up with some kind of statements of next steps, but I want to make sure we're getting all the questions.
Yes.
Okay, yeah.
Just for that, I just want to make sure I'm clear. If something is expunged, it no longer shows, but it's sealed.
It no longer shows either. There's a difference.
Is that correct?
Yeah, I'll restate the record. Restate the question, please.
So the question is about the difference between expungement and sealing. We talked about a few of them on the front. You're only eligible for expungement if you have a non-conviction record. You're only eligible for sealing with a conviction or certain deferred dismissals. I think a big difference, and George kind of touched on this earlier, is what happens to the actual records. So with expunged records, they're cleared from the police system and all local law enforcement. They no longer have access. It's as if the record doesn't exist. And then the court record is put into a file that's marked expunged, and it's put into a cabinet where only, you know, select people within the clerk's offices have access to it. Otherwise, you know, if somebody else that didn't have the right kind of access to it tried to get to it, they would be committing a crime. And the only way that an expunged record gets opened is if a prosecutor goes to a judge and says, I need what I think is the expunged record. I need that for an active criminal investigation that I'm doing right now. And the judge can grant an order that says, okay, you're allowed to look at that expunged record. And that does happen on occasion, I'm told, by prosecutors. With a sealed record, as George mentioned, because of the nature of it, because it's a conviction, there are certain things that people have to get access to that conviction for. So if you're the federal government, you don't care much about the state sealing law. Somebody comes and applies for a job with the Department of Defense, they damn well are going to find out about your sealed conviction. You bet on it. If there's a national security implication, if they're, what's that? Banking, yeah. If you try to work in a bank and you pled guilty to a crime of moral turpitude, like Shannon was talking about, something involving lying, cheating, or stealing, the FDIC has a regulation that says you must disclose that, or they will find it. So there, and then one of the sealing exceptions that sort of was surprising to me is in child custody cases. There will be the opportunity to open up, lawyers will have to argue over it, but there will be an opportunity to open up sealed convictions in child custody cases. If it, might be in the best interest of the child for the judge to, know about that, they'll be able, in some situations, to open up a sealed conviction. So it's, when we say that it's sealed, it is sealed for purposes of like private employers, private landlords, educational institutions. I mean, it is going to be life-changing for those situations, but there are, as George said, like 25 different instances where certain individuals or certain situations that the sealed conviction can be reopened. And again, they're put into a court file marked sealed, put away so that, people can't just access them for any old reason. But if it falls under one of those categories, they can access it.
Okay, any other questions? Yes, ma'am.
You have to have a lawyer to access all of these processes. It sounds pretty complicated, but there are ways to access it as a person,
So- So the question is, do you have to have a lawyer to go through these processes? Because we have definitely thrown out a lot of information. I'll let both George and Shiva both answer that question.
I can tell you as a lawyer, no, you don't. It is a civil procedure, whether it's the expungement or the sealing, both of them. They are civil procedures where folks can represent themselves. One of the interesting things about the sealing legislation is that there's actually a provision where folks who are indigent can apply for court-appointed counsel to do the petition for sealing for them. So I think that's a great part of the legislation. But no, an expungement and the sealing, it can be done on your own. Now, I am a lawyer, like I said. My suggestion on anything like this is consult a lawyer. Consult a lawyer, ask these questions, and find out if you are comfortable doing it yourself. But it is definitely something that you can do yourself. And, like I said earlier, some jurisdictions make it easier and a little bit more user-friendly, and some jurisdictions it's a little bit harder. But you can definitely do it on your own. I've seen folks do it on their own successfully.
In my great professional advisement career, consulting attorney. And I say that because as a layperson who has dived deep into the legislation, who has dived deep into the current law and knows these things backwards and forwards, I still need to consult Ross all the time. But like, being honest, like, it is so nuanced. It was so complicated the way that the law came together. There was so many differences in how the law should have been and what it is. Even JLARC, even the crime commission was like, what in the hell are we looking at and how are we going to rectify this against current law? So it is a complicated thing. Yes, you can file pro se, but I would advise in my very professional advisement career, my very short-lived advisement career, yes, consult an attorney, because it is a very complicated process, especially if you have convictions in multiple jurisdictions. So Yes, and yes, and yes, and yes, there is an option to, if you qualify, essentially, be given in a court-appointed attorney. There should be a list of them. If you don't qualify, still consult an attorney. It can be done. Anything can be done as a pro se person. We see all kinds of things filed pro se, but with the complications and the way that the law came together between the House and the Senate and the whole mediation, I would advise everyone to at least talk to an attorney, even if you go to do it yourself. And yeah, as the process gets better, maybe we'll be working to find people who will, craft pro se documents. But like George said, each jurisdiction has the authority to have a different process. So yes is the answer.
Right. Okay, are there any other questions in the live audience or on the? Not on the call. Okay, well, so I just want to say, thank you all very much for tuning in online as well as coming out here to beautiful Eastern Henrico. I do want to say that, this was the first information session. We called it session 1. And it is our desire to have an opportunity where we will have real interaction and have individuals be able to come into a space that will be able to, run their records, look to see if they do qualify, and then have attorneys on site to assist individuals with perhaps even filling out a petition online that is online, so that those can be submitted to the court. To be auspicious, I think we're gonna try to shoot for that maybe in February. That's a beautiful month. And what we also might do before then is going to have another information system, like another informational session, perhaps before the end of this year, or maybe right after the beginning of January, so that when we are putting together the action in February, we'll have another session close to that time. So I want to say thank you for everyone who has attended. I want to say thank you to the Henrico chapter, the NAACP. I want to say thank you, Clean Slate. And thank you, Sheba, and your No Left Turns, and our good friend Rob from, because I'm not gonna try to say your last name. From Justice Forward, and thank you from me, Shannon Taylor, the Commonwealth Attorney for Henrico County in my office. I want to say thank you for everyone for being here, and please share the information, and we look forward to circling back and seeing everybody again in the very near future. Thank you so much.